My next guest is the Executive Director of Class Action Watch, a nonprofit tort reform organization dedicated to educating the public about class action abuse. Lawrence Schonbrun, welcome to the program.
Thank you very much for having me.
Okay, so for the sake of the small portion of my listeners who might not know, what is class action lawsuit and how does it differ from other lawsuits?
Well, for my purposes and for the case that I was involved in, one of the main points of difference is that the class members don't hire the lawyer. Oftentimes, the lawyer hires the client because they hear about some practice that they believe they can sue on, representing a large number of people. The point is that the court appoints the lawyer, the court pays the lawyer, and class members typically know nothing about the case until it's settled, where they get a notice in the mail saying, you may be a member of this class. There's a tentative settlement. The lawyers are seeking these fees. If you wish to object, file a document objecting. The hearing is on such and such a date.
Okay, now you recently represented a class member in California, and we asked the court to confirm its landmark ruling in Serrano versus Priest, or more specifically Serrano 3, which I believe was decided back in 1977. And it said that attorney's fees awards were not to be based on a percentage of a settlement recovery, but on the value of the legal services performed. I'd like you to briefly explore the details of your case, but before you do that, if Serrano 3 was a landmark ruling, what happened that undid whatever good should have come from that?
That's a great question. What happened was the plaintiff's class action bar initiated a vigorous series of maneuvers, let's say, to reverse Serrano and reverse the cases that held that fees would be based upon the work done, because it meant the fees were typically lower than a fixed percentage and more work had to be done, so less fees would be obtained, so that overall they'd make less money. So they engaged in this campaign, and they were unfortunately successful because they hire prominent lawyer professors from prominent law schools to argue on their behalf. One lawyer termed the phrase blessing the fee. They asked these big shot law professors from big name law schools to bless the fee, and these big shot law professors are also heads of different committees, and they were successful in getting different law review articles written and get different professional organizations and different courts to abjure the reliance on work done and to base the fee on a percentage. And what happened in my case was that's what the judge wound up doing. In fact, the Supreme Court in my case said, we're going to follow what the federal system does. Federal system does award by percentages. So the California Supreme Court, in my opinion, rejected Serrano. I mean, they wiggled a way out of it, but really they reversed Serrano and actually did, I would argue, some major damage, pushing the law back. And the most significant, I think, aspect of this is that we had always believed, and the law and guiding principles required, that the judges and the judicial system was looking out for us, the class members, protecting class members from lawyers seeking excessive fees. And what this new case, Lafitte, did was change the whole dynamic, and now the judiciary is representing the lawyers against the class members, protecting the lawyers' interests against the interest of class members. And God forbid, if California is indeed a bellwether, trendsetter state, then this is the ignominious ruling that's going to be followed by other states throughout the United States.
Well, I live in New Hampshire, and any of us who are in the political genre, shall I say, we pretty much consider the New Hampshire court system and entire justice system right through the Attorney General's office to be awful. I don't know if it's corrupt or just self-serving, but it just seems like they bring large cases against corporations for things that the EPA made them do, and then get these huge judgments. And when I was doing my research, I noticed, I think it was around 2011, it might have been later, that you actually wrote an article about a case in New Hampshire, and I can't remember the specifics, but I was like, there's another one. It just never stops. There's so many.
I remember that. I think I remember that case.
And people don't know about these things.
No, and that's the problem. It's what it's like. I realize. I mean, when if you own any shares of stock or whatever, you get a notice in the mail. There's going to be a shareholder meeting. These are the resolutions they're going to be voting on, and you can come to the meeting and cast your vote if you want. And everyone throws those in the garbage can, or I think 99% of the people. And that's what they want, these class action notices. They want people to get them and throw them in the garbage can. And the California Supreme Court indirectly said in this case there were three guiding principles that guided fee jurisprudence in cases like class actions where individual people who are a part of a settlement don't hire the lawyer themselves, and it's the judge's responsibility to set the fee. Those three principles were the first, that when courts do that their prestige and the prestige of the bar is on the line in terms of public confidence in the system. The second principle is that judges are fiduciaries for absent class members. They're supposed to protect the interests of those people who aren't there before the court. And the third principle, going back 100 years, the United States Supreme Court, is that the courts should be guided by moderation and a jealous regard for the rights of those who have a financial interest in that fund that's been recovered. None of those principles is mentioned in this decision. So this is the way modern-day courts are behaving. None of those principles that are supposed to protect us, the class members, against them, the lawyers, those principles no longer exist. Indeed, the California Supreme Court said that the guiding principle is how can we incentivize lawyers to litigate cases efficiently? That's the new guiding principle.
Efficiently. Well, talking about efficiency, I guess you would have to consider cost, and of course the settlements are often enormous, and the lawyers collect huge paydays from them. But it reminds me that of an old adage that businesses don't pay for higher taxes and regulations; their customers do, and this applies to class action awards as well, too, doesn't it?
Well, this is directly the case. This money, in fact, there was a concurring opinion, which we can perhaps talk about, but the concurring opinion repeated what I had said, that every dollar that goes to these lawyers, because it's a common fund that's settled, and then the lawyer's fee come out of the fund. So every dollar that goes to the lawyers is a dollar that's not going to go to class members.
Are there any state legislatures or Congress, is anybody looking at correcting the problem of class action abuse or excessive attorney fee awards?
It's interesting. These lawyers have really, the plaintiffs' lawyers really kind of control this industry. There are some maverick, and I mean that in the positive sense, judges who don't buy this line about how great class actions are and how they're the only way to protect the citizenry against abuse by corporations. but the overwhelming majority of judges, in my opinion, judges, law professors, lawyers, are basically in on this, for lack of a better term, racket. And in terms of state legislatures, again, I can't speak for the legislatures throughout the United States. I know that this percentage method, except for two states, the percentage method is used, as I say, in all the federal courts and in all state courts as well. In those courts, it's an option. The judge can go either way as the choice of which method he wants to decide. In other words, the laborious method of looking into what the lawyers did in the case actually, or the much less laborious method of taking the settlement, as they did in my case, multiplying by 33.33% and coming out with a fee. And these percentages are ridiculous because these percentages are borrowed from individual tort cases. You and I are in a car accident. We hire a lawyer or a law firm to represent us, and typically the lawyer takes a third, maybe 25%. And they're using that paradigm in a circumstance where there are thousands and millions of class members and dozens and scores of law firms. In other words, they handle the case wholesale and bill their clients retail.
Now, you suggested a remedy, correct, to assist class members, somebody to basically represent their interests in this?
Yes, I did. And I want to point out that the main opinion mentioned nothing about my arguments. And I believe the reason they did that because it would be that to state my arguments, there's really no intellectually honest refutation to my arguments, so they didn't even want to put them on paper. Thank goodness there was one concurring opinion that agreed with me, but what I argued was that class actions are unique because the class members don't hire the lawyer, they don't set a fee for the lawyer, and when a case is settled, at that point, the lawyers no longer represent class members because they've got the settlement from the defendant. Now they're representing themselves against the class members to get their fee, to reduce their client's recovery. So they file declarations, they hire experts. There's no one on the other side. The class members have been abandoned by the system, and I argued that in every case where the lawyers were seeking a fee of $1 million or more, and there are tons of them, that the court should appoint a class guardian, that class guardians exist, for example, in estates to protect decedents' estates. They exist where minors are involved in accidents to protect minors' interests. And I argued that the mechanism was there and it was very applicable in this case. And the main opinion said nothing about my argument, as thank goodness one of the concurring judges said that he believed that it was a good idea if the fee request was very large, without specifying what very large means. But the court system is in denial about this, and it's below the radar. That's why I have been trying to educate and make the general public aware of what's going on. Most people have no idea. And the amounts of money we're talking about, we're not talking about even race money to buy thoroughbred racehorses or money to buy, Vail, Colorado condos. We're talking about generational wealth. We're talking about $100 million, 200, 300 million, 400. I was involved in a case. 500. I'm sorry, $700 million. The fee awards we're talking about are, if you look at it by the hour, $1,500 an hour. My case. Another case I'm involved in, $2,500 an hour. I'm aware of a case where the lawyers sought $7,700 an hour, and this is for thousands and tens of thousands of hours of work. So when you're talking about fees of this size, you're talking about the money that can control the political process, be it money given to senators and congressmen, and lawyers, I believe, are the largest or the second largest contributors to political campaigns, judicial campaigns, the awards they give to what I'm thinking about, writers, to journalists, the awards they give to journalists. They can basically control the whole system, which is what they're doing. And it's a hidden, what's the word? There's this analogy about an octopus. They've encircled the legal system with their 7 or 8 or 12 arms, and they're squeezing it for all the money they can get out of it.
So we're getting close to the end of the segment.
Okay.
How long have you been at this, and what attracted you to the issue?
Unfortunately, about 20 years. And I was attracted to the issue because I wrote an article for a legal magazine about law firm billing practices and the corporate consumer. It was called Timekeepers Without Watches. And a lawyer read that, and they had gotten a class action notice in the mail. And they said, well, you might be interested in this. You've been writing about legal billing practices. And I found out that no one was protecting the class members in this circumstance. So I've been arguing this for 20 years unsuccessfully, but it was a cause worth fighting. It involves basic due process. It involves basic adversarial nature of our legal system. I mean, these are really miscarriages of justice, and I was stupidly got involved in it. Couldn't get out.
Well, once you got started. So
Yeah.
people can Google Lawrence Schonbrun, and that's Schonbrun. You will get tons of articles to read about this. And
Huffington Post included.
Huffington Post included, yep. So how would anybody else get a hold of you?
Well, just Google. I've written 24 articles about this. I've been in 100, 200 class actions, so they can typically find me.
All right. Well, thank you so very much for spending some time with me.
Thank you for having me.
All right. You have a great evening, or afternoon in your case.
Bye-bye.
Bye-bye.